Hello, my name is Vinisha Jain and I am a student of Institute of Law, Nirma University, currently interning with the Amicus Qriae organization. This is a PPT regarding SEBI recent developments through case laws. In this PPT, two case laws have been discussed that were responsible for substantial developments in SEBI laws in India. Beginning with the first case, that is N. Ravichandran versus SEBI, which was decided on the 2nd June 2020. In this case, due to the commission of some illegality or irregularity, the appellant was debarred from trading in or accessing the securities market for 5 years by SEBI on 5th of November 2019. In May 2020, the applicant, however, requested SEBI to allow him to subscribe and convert his physical shares into demat form for the purposes of rights issue of Reliance Industries Limited. The applicant was an existing shareholder of the Reliance Industries Limited, which had announced a rights issue during that time. These are where the facts of this case end, and moving on to the next slide, the order in this matter given was that SEBI allowed the applicant to subscribe to shares for the rights issue and to also convert his physical shares into demat form. The same was done with giving the rationale that giving such a permission to the applicant does not dilute the restraint imposed on him. The reasoning given was that applicant was a shareholder of Reliance Industries on the date of the order, and the activity of subscription to the rights issues and to convert physical securities into demat form is more in the nature of availing benefits of a corporate action than being in the nature of accessing the capital market, and therefore it does not dilute the restraint imposed on trading or accessing the capital market which was imposed on the applicant. Therefore, the development through this case law, as given in the next slide, is that SEBI through this case law has set precedent wherein under special circumstances such as rights issue in the present case, a debarred entity can be permitted to take certain actions in the securities market so long as it does not dilute the restraint imposed on such entity. Having understood this development through this case law, we move on to the next case, which is the case of Shruti Vora versus SEBI, which was decided on the 12th of February by Securities Appellate Tribunal. In this case, a show cause notice was issued to the appellant by the adjudicating officer, and the officer provided all the documents on which reliance was placed by it for issuing the said notice with respect to an ongoing inquiry against the appellant. The appellant demanded to also inspect all other documents other than the ones already provided to her by the adjudicating officer. Therefore, the issue in this case was that whether a person against whom an inquiry is ongoing is entitled to inspect all the documents which are in the possession of the adjudicating officer. Regarding this matter, the order which has been given in the next slide is that SAT said no provision exists at all in the relevant statute, that is, the SEBI procedure for holding inquiry and imposing penalties by adjudicating officer rules 1995 regarding supplying copies by an adjudicating officer to a person against whom a show cause notice is issued. and the same is in practice only as the principles of natural justice require the same. Hence, the reasoning given by the appellate tribunal here was that there is no law at all dealing with presenting documents by adjudicating officer to any person against whom an inquiry is going on, and the requirement or the action of the adjudicating officer in the present case of providing the appellant with the documents on which reliance was placed for the show cause notice issued to her was in the spirit of fairness, that is, a principle of natural justice and not any existing law. And therefore, the issue was answered as that there is no requirement for any adjudicating officer to present all the documents in his possession to any person against whom an inquiry is going on. Therefore, moving to the next slide, the development in this case was that SEBI has set a precedent that wherein the law is silent under the Rule 4 of SEBI Procedure for Holding Inquiry and imposing penalties by 9 Adjudicating Officer Rules 1995 regarding providing for inspection of documents by a person against whom an inquiry is being going on is not required, and therefore in any case the same needs to be done only to the extent which is required by the principles of natural justice and no further. And therefore, through these two case laws, precedents have been set for certain situations for which the law is currently silent. The same also clarify the positions with regarding these events. Thank you.